We're here in the studios today with Ted Topouzis, and he's the partner at Topouzis and Associates, located right on Jefferson Boulevard, right in the dead center of Rhode Island here, covering all of Rhode Island, Massachusetts, and Florida real estate.
That's right.
Right?
That's right.
And Ted and I are going to be discussing with you, we're talking about the different ways to take title on property, right?
That's right, Emilio.
Yeah, Ted, take it away, man.
All right.
You're the guy.
Thank you.
You're welcome.
So this comes up in closings all the time. At least I see it very frequently when you spend a few minutes of time right at the beginning of the closing talking about something really important, and I think at least I felt that it was definitely worthy of a segment on your show, because people need to know and maybe even spend a little more time thinking about the consequences of taking title to a property and the different forms of vestings that people could take title to, especially when it has to do with more than one owner. So most people spend their time and attention on purchase price, properties appraising out, qualifying for a loan, interest rates, inspections, repairs. The gist of it here. Closing cost credits. But they don't think too much about how they take title.
It's true.
And it is an important thing, I think, very important. Again, when it's one person taking title to a property, no big deal. You don't need to put too much thought into it. The issue comes up really when it's a combination of several people, or maybe more than just two people. And the typical examples of co-ownership, or John Doe, Mary Doe, or maybe there's three people, A, B, and C on title. Where I typically find this to be a concern is when first-time home buyers, a young couple, probably not even married yet, is the routine, just dating and say, well, I'd rather buy a house instead of renting, and it's a great idea, no question about it. I mean, it's probably much less expensive, but they don't think about the consequences of purchasing that property as a single people, before they get married.
True.
After marriage, things definitely change. So, and also the other little twist on that to consider is what happens when these two people are coming up with different amounts of down payments. So one's coming up with a lot more money than the other. Do you really want to take title to that property as with a survivorship clause as joint tenants with rights to survivorship, which is one of the ways to take title, and then God forbid something happens to one of these kids. The one that pays more into the purchase price, the purchase of the property, have that investment kick over to the co-owner who didn't put in that investment, as opposed to letting that investment, that interest in the real estate pass to an heir. So, these are some of the things that I wanted to bring up and have you think about. So there are several different ways to take title as co-owners of a property, and the most basic form I wanted to point out is tenants in common, and that's where each party. Each owner has an equal right to possess the property. The presumption when you're a tenant in common is that the interests in the ownership are equal, although it doesn't have to be. It doesn't have to be a 50-50 percent interest to each person. For example, A can own 3/4 of an interest and B can own the other quarter. So it doesn't have to be 50-50. Although if you don't identify the percentages, it reverts back to an equal distribution. That has to be listed on the deed in order to have effect. When a co-owner of a tenant in common property has a judgment, tax or lien, that would attach to that co-owner's interest and has to be satisfied or released prior to the sale of that property.
Okay.
That's very important. Just because it's against one of the two people doesn't mean it doesn't attach. That's probably a very common misconception and has to be pointed out. Another important facet of this type of ownership, the tenant in common, is that there's no survivorship provision. So it's so if a co-owner dies, that interest would pass to their heirs or devisees, subject to any liens that co-owner may have. So,
Sure.
so the survivor, the person that is still around, can't sell that property immediately. They have to wait until the heirs of the deceased file a probate and get the court's approval to be able to convey that
What
property.
if there's no heirs? Does it go to the other co-owner?
No, it would have to go through the
State?
Yeah, it may have to go to
Wow.
the state.
So-
or there's typically
So that's the
heirs.
downfall of
That
this.
could be the downfall. Yeah, there's
Okay.
definitely and there's also an extra expense. I mean, that's probably the primary consideration in that
Yeah.
type of situation where you have a tenant in common situation. You have to understand that there's that possibility. It's of course it's very unlikely for a young couple or anybody. You don't
Yeah.
chances are you won't pass away during the ownership of that property, but it can happen.
Let's say somebody, towards their retirement, let's just say if they're buying their last house, they're married, what type of tenancy should they have?
They should have, if they're a married couple, they definitely would want to, and they'd be, entitled to have ownership through a tenancy by the entirety.
Okay.
And that's language that would have to be listed on the deed. If you don't list it on the deed, the vesting automatically reverts to the simplest form of vesting, which would be that tenancy in common. So you want to definitely make sure that that vesting is identified on the conveyance.
Who takes care of that? That would be the attorney.
That would be the closing attorney, typically the seller's attorney, or even the buyer's attorney if the seller's attorney left a blank on the vesting, because the seller's attorney may not want to presume that
responsibility.
Yeah, that's the way they want to take title. So it would be listed on the deed before it gets recorded.
Ted, question for you. I'm sure a lot of
Sure.
our listeners are wondering the same thing. Now, what happens if they start at tenants in common under the title and
They get married afterwards?
Yeah, and they're not selling the property, and then they want to be tenants by the entirety. What's the process for that?
They can just simply execute a new deed and change the vesting from tenants in common to a tenants by the entirety or a joint tenants with right of survivorship. Typically when people get married afterwards, that would be the right thing to do.
Yes.
Because
We are in wedding season too, by the way. So
yeah, sure.
Yeah.
No question. I mean, you might have the situation where you have the young couple that purchased the property and eventually they get married, and and that's something that they should definitely consider along the way and make that change on the deed. It's important because it's an estate planning mechanism.
Yes.
You don't want to go through a probate if you don't have to. And there's expense, there's delay, and it's unnecessary. So, a couple of the important components of a tenancy by the entirety are that only a married couple can have that type of vesting. And in 2015, the U.S. Supreme Court actually opened that up to opposite sex and same-sex marriages. So you see that coming into play. Again, you got to put that wording on the deed in order to have the benefit of it. And if there's a lien against one of the spouses, it doesn't attach to the property. If there's a lien against both, it's a different story. So it does attach. There is a right of survivorship, an automatic right of survivorship, which is really key because that's the estate planning component. When one of the spouses passes away, the surviving spouse automatically takes title to the property. So it's right away that she can, he or she can decide to sell the property if they need to because they had a financial, both parties were participating in the finances of maintaining the property. So that's a really, really important provision. So, typical examples of a tenancy by the entirety would be listed as a John Doe, Mary Doe, as husband and wife, and as tenants by the entirety. So it'd be husband and wife as tenants by the entirety. You got to list that on the deed. It's important. And the attorney that you have, the real estate practitioner, would know that, and has to list that, or else you would be taking title as just simple tenants in common. I wanted to mention briefly. There's one in between vesting, which is called joint tenants with rights of survivorship, and that's a form of co-ownership that where the parties, the co-owners, are not married. Not married people. They have to be natural people. You can't co-own a property with a company or business entity. Very, very quickly, it's there is this survivorship provision as well, where the co-owner, if a co-owner dies, the surviving owner would automatically take title to the property, and if there's a judgment, tax, or other lien against that co-owner, that would attach to that co-owner's interest if they're selling the property together, would have to be settled at or before the closing. But if that co-owner dies with that judgment or lien, then the surviving tenant doesn't have to takes title without that lien attaching, unless it's a federal tax lien. Yeah.
Okay. Wow. So that would just kind of go away like bankruptcy type of situation.
Yeah. It just doesn't even. He or she that survives is the benefactor of that property without that lien attaching.
That's very interesting.
It's something that is good to know. So again, with tenants, by the entirety, same with joint tenants with survivorship, you have to spell it out on the deed, or else you don't get that benefit. And you have to list it out, for example, as John Doe and Sarah Smith as joint tenants with rights to survivorship. If you don't spell it out like that, you revert back to a tenancy in common.
You want to make sure that deed is recorded right, okay? And even as a real estate professional, I wouldn't write up a deed, okay? You can do it if you're a person. You can also sell your house for sale by owner, but we all, the statistics are there. Doing all these things on your own, you're leaving yourself, your family, your heirs exposed.
No question. You want to leave decisions like this, the preparation of these legal documents, to the professionals. A real estate attorney, you have to.